Thank you again for joining us here at the Heritage Foundation in our Van Andel Center. We welcome those, of course, who join us on our heritage.org website on all of these occasions. Would ask everyone here in-house to check cell phones to see that they have been turned off as we prepare to begin as a courtesy. And of course, we invite our internet viewers now or at any time in the future when viewing our replay of this program to send their questions or comments, simply emailing speaker@heritage.org. Hosting our discussion today is James Shirk, Research Fellow in Labor Economics in our Center for Data Analysis in the Institute for Economic Freedom and Opportunity here at Heritage. He joined us in 2006 and researches ways to promote competition and mobility in the workforce instead of erecting barriers preventing workers from getting ahead. His commentary and analysis has appeared in numerous publications. He has also been a guest expert on many television and radio programs. He earned his bachelor's degree in economics and mathematics at Hillsdale and received his master's degree in economics from the University of Rochester in New York. Please join me in welcoming James Shirk. James?
Thank you, John. Something almost unprecedented in American labor law has been happening over the past few months in Kentucky. As of December 1st of last year, there were 24 right-to-work states in the nation, 26 states without right-to-work laws. Right-to-work simply means that workers have a right to work whether or not they pay union dues. Unions cannot negotiate contracts and then impose those contracts on workers that force them to get fired if they don't cough up $500 to $1,000 a year worth of their salaries and in tribute to unions as dues. Now, we have 24 states, now 25 that Wisconsin passed it, with right-to-work laws, 25 states without them. But starting with Warren County in Kentucky and followed by 11 more counties throughout Kentucky, local county governments began using their powers under the state's home rule ordinances in order to pass their own local versions of right-to-work. The state legislature was deadlocked. The state Senate supported right-to-work, had passed it. The state House made it clear that the votes just weren't there. And so rather than wait and just allow that gridlock to block any progress on the issue, Bowling Green and now in total a dozen counties covering almost 600,000 Kentuckians have passed local right-to-work ordinances. Now this is so unusual because there are no other localities anywhere in the country that have done this. You can go to Ohio, you can go to Pennsylvania, you can go to West Virginia, Maine, New Hampshire, Illinois, many other states where right-to-work has been a hot topic, where there's been a big push for it, and localities haven't done it. And the reason for that is that a lot of people have interpreted the National Labor Relations Act to simply only allow state right-to-work laws. But the counties have made a new and I think a very strong and very compelling legal argument that the National Labor Relations Act in fact allows them to pass these local ordinances. And so here to discuss this, we've got two very distinguished speakers. We've got Jim Waters, who's president of the Bluegrass Institute, the local free market think tank in Kentucky. He's been one of the leading voices on the ground, encouraging this as a course of action, and writing and speaking about the benefits that right-to-work can bring and has brought to many in Kentucky. We also have Jason Nemes. Jason Nemes is practices in law with Fultz, Maddox, and Dickens, and he is one of the lawyers representing the counties who have been sued by the United Auto Workers. So UAW versus Hardin County. All the arguments and briefs have been filed in a federal district court as of last Friday, and now both sides are simply waiting for the court to hand down its decision. But Jason was the one, one of the ones on that legal team who's been handling the defense. The copies of his briefs were available there on the table on the way in, and you can also pick them up if you'd like on the way out. And Jason will discuss the legal defense and why he thinks that, despite the fact that nobody else has really tried this up to now, he thinks that the counties do have a solid case for their defense. And so with that, why don't we lead it off with Jim to discuss the policy implications of this move.
Well, thank you. Greetings this afternoon from America's first right-to-work county, Warren County, Kentucky. It just happens to be where I live. And it also is the same county where the Bluegrass Institute, I'm proud to say, started 12 years ago. And it's also where another gentleman you probably heard of, a man by the name of Senator Rand Paul, is from and made his first historic run for office. But first of all, I just want to take just a moment today to thank James and the Heritage Foundation for this opportunity to participate in this event today. I also want to thank Jason Nemus, a co-laborer in this effort, and we've been all over the Commonwealth of Kentucky, and I think we've got some more miles to go. And I also wanted to express my appreciation for the opportunity we had this past Wednesday in Seattle to update the leaders of the conservative movement nationwide on our local right-to-work efforts at the Heritage Foundation's Resource Bank meeting. My thanks to Bridget Wagner especially for once again putting together a great event. The feedback that I've gotten from around the country from leaders who were at that event suggests that what's happened in Kentucky could be an important beginning to a national movement to find and take local paths to right to work in those 25 states, as James mentioned, in which employees at unionized companies still are forced to pay union dues or lose their jobs. You know, and for years, and James alluded to this, but for years we in Kentucky have banged our heads against the proverbial wall of political gridlock, being the only southern state really without right to work and one of only 6 in the nation with a divided legislature. However, I got a call in November one day from National Legal Brent Yessen, a colleague of ours in this effort, from a group called Protect My Check, and he began to explain to me how 37 years ago the Kentucky General Assembly did something that General Assemblies usually don't do. They passed a clearly written law that provided a clear path for counties to pass economic development ordinances like right to work, and he wondered if I would be interested in knowing more. I asked him if birds fly and the sun rises in the east. Of course, we'd be, after all this work on right to work, absolutely. But what I discovered was that the Kentucky General Assembly in 1978 not only passed a strong but very clear county home rule statute containing language clearly delegating to county governments the authority to pass economic development ordinances, but also to regulate commerce and, this is interesting, to protect workers and citizens in their counties, which right to work also does. The fact is that right to work fits the county home rule like the Kentucky Wildcats fit in Rupp Arena, and is now protecting workers, as James said, in 12 counties from losing their jobs just for refusing to become union members or pay dues. While also serving, these ordinances are serving as those counties' very own open for business signs in a state that generally has not been. 4 other counties also, by the way, have taken first steps toward doing the same and are about halfway there. So the ordinance is so clear, or the statute is so clear, that Kentucky's Democratic Attorney General didn't even mention it in his opinion, which somehow or other appeared just a few minutes prior to Warren County Fiscal Court passing the second reading of their ordinance on December 19th. And it just happened to appear on the desks of the local magistrates. And all of this after leadership in Frankfort and in the legislature had asked for months for an opinion on this issue. Well, anyhow, Protect My Check said they would provide the legal help if the Bluegrass Institute would fight the policy battle. And I said, absolutely, I'm privileged to do that, and it's been a great partnership. One of the reasons the Institute, I think, has been able to have such impact in this campaign is that we had leadership years ago that understood the importance of educating citizens, and that when you educate citizens, that's really the only effective way to change their political representatives. So we had a board that supported our weekly syndicated column called the Bluegrass Beacon, which we've been writing now for more than 8 years. I have a couple of copies about this issue out in front if you'd like to take those afterwards. But it presently appears in more than 40 publications statewide, and we just picked up another newspaper this week because of the right to work issue out in far western Kentucky, where we traveled out there to make our case, and where the magistrates of Fulton County, the further western part of Kentucky, unanimously voted to make their county a right-to-work county. And the reason I mention this is that Fulton County once had Kentucky's highest unemployment rate. They had an unemployment rate not that long ago of a whopping 20%. And no wonder they've been able to cut it now to below 10%. And because they passed right to work, they believe that this will help them lower it even down to around 6%, which would be below the national average. Fulton County's leadership believes that a right to work policy for their county will shave 4 points off of their unemployment rate. That's pretty interesting. I even had the editor of a small newspaper out in that region tell me this week that she is supporting right to work so she can grow their newspaper business, they can sell more ads, and they can have, in her words, a prosperous community. The first exposure that Kentuckians had, most Kentuckians had, to how this county home rule statute could provide a path for local governments to implement their own right-to-work policies was through that column. And the results are unmistakable. I think there's been like 118 votes now taken, final votes, in the past 140 days or so on right-to-work policies. 113 of those have been yeses, only 5 have been nos, and many of those who voted for this are Democrats. Well, we write columns, but we also go to these places. We go to these fiscal court meetings where government closest to the people is at work, and we educate those elected officials, the citizens, and even the labor unions themselves, not with anger or emotion or malice, but by using relevant data, like the data we gathered from the National Institute for Labor Relations Research, the U.S. Census Bureau, and the Bureau of Economic Analysis. We use the data gathered from these credible sources to tell those magistrates that real manufacturing GDP grew by 87% from 2002 to 2012 in those 22 states with right-to-work laws, but fell by 2% in states without right-to-work during that period. We tell them that employment, incomes, and populations grew by 43, 209, and 39% respectively in states with right-to-work laws in the decade between 1990 and 2010. We tell them about the census data that shows that more people, primarily younger adults, are moving into right-to-work states. Between 2000 and 2009, more than 4.9 million native-born Americans moved from non-right-to-work to right-to-work states. That's an average of more than 1,450 people every day. Well, we tell them between 2002 and 2012, the population among the 25 to 34-year-old age group grew by more than 11% in right-to-work states, while non-right-to-work states saw an average of only 2.5% growth, but in Kentucky, we were behind all of that. We lost over a full percentage point of that population in that age group. We encourage these local leaders to consider what that means for young people getting out of college and looking to begin careers. We tell them how research by the World Bank, of all places, indicates that right-to-work Tennessee's 3 most populated counties bordering non-right-to-work Kentucky experienced nearly 16% growth in private sector employment between 2002 and 2012, while employment in the 3 most populated Kentucky counties along that same Kentucky-Tennessee border grew by less than 4% during that entire decade. We tell them that growth in private sector employment in non-right-to-work Kentucky counties was only 25% that of right-to-work counties along that same border during the same time period. We tell them how the last automotive manufacturing plant built in a non-right-to-work state in America was built, ironically, in Kentucky. The last automotive manufacturing plant built in a non-right-to-work state in America was built in 1987, in the mid-1980s, in Georgetown, Kentucky. That every other auto manufacturing plant since then has been built in a right-to-work state. We tell them how companies like Toyota are moving hundreds of jobs from Kentucky to right-to-work Texas. How the Beretta gun manufacturers built a new $50 million manufacturing plant 24.6 miles south of Kentucky's border in Gallatin, Tennessee, right-to-work Tennessee. We tell them how the Caterpillar had a spot picked out on the Kentucky side of the border to bring hundreds of good jobs, but then went to Georgia when they found out the Bluegrass State has great basketball teams that win championships. They have an economic development bureaucracy that's good at offering taxpayer taxpayer-backed incentives, but it doesn't have right to work. We tell them the Business Insider ranks Kentucky's economy number 44 out of 50, and that Forbes ranks Kentucky as number 44 out of 50 in its best and worst states for the new economy. CNBC ranks Kentucky number 36 in its state business rankings, much lower than right-to-work Tennessee to the south at number 13, and Indiana, right-to-work Indiana to the north at number 18. We tell them that the Bureau of Economic Analysis reports that while growth occurred in 49 states in 2013, Kentucky's dismal 1.6% growth in its gross domestic product was below the national average, and that Art Laffer, we tell them that Art Laffer, a respected economic advisor to President Reagan, ranked Kentucky number 39 in his 2014 Economic Outlook rankings. Only Illinois was ranked lower among Kentucky's neighboring states. We tell them that while the labor bosses claim that right to work lowers incomes and diminishes opportunities, that it actually, we show them how right to work has brought rapid growth in jobs and wages in places like Indiana and in Michigan since those states passed right to work in 2012. We tell them how there are 142,000 more jobs in Michigan now and 50% higher wage growth now than the national average since that state, the home of the UAW, passed right to work. We tell them how incomes increased by an average of $1,000 in Indiana just the first year after right to work was implemented. It went up even more for workers who chose to keep their hard-earned money in their pockets rather than give it to labor unions to send to Pittsburgh or Washington or Chicago to support big government and progressive political causes that they personally don't believe in. We tell them how Warren County's Mike Buchanan, now as judge executive of America's first right-to-work county, now finds his county on the site selection list of more than 30 brand new companies, representing more than 3,000 new jobs, over $300 million in capital investment. Those are new companies for Kentucky, that is. We tell them how that compares with 1,318 net new jobs from new companies that came to Warren County during the entire decade between 2004 and 2014. Let's see, 3,000 new jobs in 90 days after right to work versus 1,300 net new jobs in the entire decade prior to that. We tell them how that between 2001, when Oklahoma passed right to work, and 2012 in the Sooner State, average weekly wages increased from $551 to $801 by the end of 2012. That figures out to an annual raise of around $13,000 eventually. We tell them how more than 90% of both their Republican and Democratic peers have voted for county right-to-work laws. We show them that right to work is even good for labor union membership, that the states with the fastest growing labor unions are without fail right to work states, including Kentucky's neighbor Tennessee, where union membership increased 25% by 31,000 new members just in 2013 alone. We also tell them that Gary Castile, the Southern Region Director for the UAW, said recently that he prefers right to work environments for organizing. This is something I've never understood, Castile said, quote, that people think right to work hurts unions. To me, it helps them. But we do admit to the magistrates that while union membership, while right to work is good for the rank and file members, it's really hard on the bosses who can no longer force workers to give up 2% of their income in the form of labor union dues just because they happen to work at a unionized plant. And we do tell them how that last year, according to its LM2 form, the local United Auto Workers Union 2164 in Warren County at the GM Corvette plant there spent only 2% of workers' dues on representation, with the rest going elsewhere. And we do remind them that while the head of the Local 2164 shouted at the Warren County Fiscal Court members that their vote for right to work meant he would lose half of his union members, that while he may in fact lose members, it's probably not because of the right to work ordinance, but rather because of the fact that wages have been stagnant at that plant for the last 7 years, and that rank and file union members, when given a choice, will say, I know how to spend that money better. But we also tell them that this is more than just about economics. This is about individual liberty. This is about families. This is about their future. This is about our freedom. This is about the 600 people who lost their jobs in a small Russell County, Kentucky, last year when Fruit of the Loom closed its last manufacturing plant there and moved those jobs completely out of the country. That one decision cost that county 1/3 of its entire manufacturing base. Now, like most Kentucky communities, Jamestown is a close-knit community. Generations of family members worked at that plant. Families were raised, college tuitions paid, paychecks were spent in that community based on the employment provided by that company. A gentleman we met named Claude Morrison had worked there for 30 years, many of those years with perfect attendance. His wife Terry had also worked there previously, but had left to try to better herself and she got her master's degree. Their education. My point is, these are not people who want to sit back and collect a check, but these are people who love their families and communities and who don't want to just pick up and leave after 30 years. Despite her educational achievements, Terry Morrison finally found a job, but it's 2 hours away and it's for barely more than minimum wage because of the distance. She has gone from home 3 consecutive weeks each month. This all has very real consequences. You know, Terry tells about how when her father died on July 1st and her sister passed away on July 10th, she wasn't able to be there to help out like she would have been had she had a good employment opportunity in her community. August 21st was their first birthday of their granddaughter, but she missed it. She missed her first teeth arriving, her first steps, and her first birthday party because the only employment opportunity she could find was 2 hours away. The Morrison said, "We don't want to sit around and wait on a check to arrive at the first of the month. We want, and we should have, the right to work." And their judge executive in that community agrees. He told us, quote, "This should not be a political or party line issue. This should be about what's best for our fellow Kentuckians who are looking for and will take advantage of opportunities when they have them." So I know we do have a legal case pending, but the fact is today that at worst, we've already had a referendum on local right-to-work ordinances, and right-to-work has won. 600,000 Kentuckians today are covered by those right-to-work freedoms, but we won't quit until every worker in Kentucky and in America is free. Thank you very much.
Thanks, Jim. I'm going to talk a little bit about the lawsuit. I'm going to give a quick sketch of the lawsuit, and then I'm going to give you 2 reasons why I think that my client, Hardin County, will win. I'll start off by saying, however, that my name is Jason Demas. I'm a lawyer at Fulton, Maddox & Dickens in Louisville, Kentucky, and I do represent Hardin County, and that's the county that's been sued in Kentucky. And the claim by 9 unions who have joined together is that the counties do not have the right to enact the local right-to-work ordinances because they are preempted by the National Labor Relations Act. So just a quick sketch. We have 12 counties in Kentucky that have passed right-to-work ordinances. All of these counties, or most of these counties, are either on the Tennessee border, Tennessee's a right-to-work state, or they're on a major thoroughfare, a major interstate in Kentucky. Hardin County is just south of Louisville, which is the big city in Kentucky, and they are on I-65, which is a major corridor through Kentucky, connecting right-to-work Indiana with right-to-work Tennessee. About an hour and a half south of Hardin County is Warren County, which was the first county to pass the right-to-work ordinance. So we've had cross motions for summary judgment. I won't get into too much legalese. That's kind of boring, but they've moved for summary judgment, the unions, and we've moved for summary judgment, and everything is now briefed to the U.S. District Court in Louisville, and the judge will likely call us in for oral arguments and then make a decision, and we'll go from there. There have been a number of amicus curiae briefs, which is not unusual for this type of case, but it is unusual for this type of case at the district court level. You guys know that's the trial court level, and then after the district court, we'll go up to the Sixth Circuit Court of Appeals. The Kentucky Attorney General, the National Labor Relations Board, and the Kentucky AFL-CIO, Kentucky chapter of the AFL-CIO have submitted amicus briefs on behalf of the unions, and the Kentucky Senate President, who's a Republican, and the other 11 counties that have enacted the ordinance have submitted separate amicus briefs on behalf of Hardin County. So that's kind of the procedural posture of the case. Now for the sexy stuff. What's the legal argument? Well, the legal question is simply stated whether counties can enact right-to-work ordinances. Now, when you get a little bit more in depth, it's whether counties can write, or whether local political subdivisions. In Kentucky, we have counties, other places have villages and so forth. But whether local political subdivisions of a state may enact right-to-work ordinances under Section 14B of the National Labor Relations Act. Now, here's the language that's important. This is, in the very end, is what is pretty much the entire case's argument is about. But here's the section. It's 14B of the NLRA. Nothing in this act shall be construed as authorizing the execution or application of agreements requiring membership in a labor organization as a condition of employment in any state or territory in which such execution or application is prohibited by state or territorial law. State or territorial law. So break that down. What does it mean? It means that the assumption is that unions can have union security clauses unless state or territorial law says to the contrary. Now, there are 2 reasons. So that's the question. But there are 2 reasons why I believe that we're going to win. And these are independent reasons. The first reason is I don't think that the National Labor Relations Act ever preempted the field with respect to right-to-work laws. Let me break that down a little bit. I don't think everyone in here is a lawyer. What preemption means is before Congress gets involved, states can do anything it wants to do, right? Anything that's appropriate under their constitutions and so forth, or that haven't been exclusively given to the federal government or the enumerated clauses. That's a matter of first principles. States can do those things. Now, when Congress gets involved, if they get involved in a certain area, they can get involved in conjunction with the states, or they can get involved and overturn or occupy the field, preempt the state's allowance to do anything. Now, before the Congress got involved in labor relations, it's clear that the states and counties, provided that the counties had the authority by the state, could enact right-to-work laws or any laws with respect to labor relations. So what changed? Well, the unions say what changed is the Wagner Act from 1934. And if not the Wagner Act, then the Taft-Hartley Act from 1947. Well, they're wrong about that. And they're wrong because the Wagner Act didn't even speak to it, didn't talk about right-to-work laws. But what happened between 1934, when the Wagner Act was passed, and 1947, when the Taft-Hartley Act was passed, amending the Wagner Act, was 12 states were right to work. 12 states were right to work. Remember, the Wagner Act didn't speak to it, as 14B in the Taft-Hartley Act, which I just read does. So the union sued before the Taft-Hartley Act, and they said, hold on a second, Congress has occupied the field by enacting the Wagner Act. You can't do this. You 12 states can't do this. So Wisconsin, the case, it's the Algoma plywood case. Wisconsin was sued, and the right-to-work law was challenged. And the U.S. Supreme Court said the Wagner Act did not prohibit Wisconsin or the other 11 states from enacting right to work. So we know that Congress didn't preempt the field by enacting the Wagner Act. Well, okay, so then they come back and they enact the Taft-Hartley Act in 1947, and they do include the Section 14B, which says nothing in this act shall be construed to prohibit states or territories' rights. Okay, so the unions say, even if we're wrong on the Wagner Act, that's clear that Congress then intended to occupy the field and then give a little bit of authority back to the states. The problem with that is the House report, the Senate report, Senator Taft and Representative Hartley all said that that wasn't what the National Labor Relations Act was doing. The conference committee said it was never the intention of the NLRA to preempt the field. And more to the point, when people say, well, then why are we having Section 14B at all? Why even put it in there? The conference committee said it was to make certain that there should be no question about this, close quote, this being whether or not states had the authority. Now, the Taft-Hartley Act was enacted in 1947. As a quirk of history, the Algoma Plywoods case, which said that the 12 states, Wisconsin in particular, had the authority to enact right-to-work states, came out in 1948. Now, it was after the Taft-Hartley Act, but they were not interpreting the Taft-Hartley Act because at the time that the lawsuit was begun was pre-Taft-Hartley, so they were interpreting the Wagner Act. And the U.S. Supreme Court said that there was no preemption. So nothing changed either in the Wagner Act or in the Taft-Hartley Act with respect to preemption. Okay, so that should end the question, right? Counties, states had the authority before the Congress got involved. Congress got involved and they didn't occupy the field. They didn't preempt state and county law, therefore end of the question. Okay, but if we're wrong about that, we have a second argument, and that is this. Even if there were preemption, either by the Wagner Act or the Taft-Hartley Act, clearly 14B enables state law, state or territory law, states or territories to enact right-to-work laws. Well, within that state law is political subdivisions, is county law. And now I think we need to step back and understand the first principles as I said earlier. What is a county? A county is nothing except for a part and parcel of the state sovereign. It only has the rights that the state gives it. State can add to those, can remove those, can eviscerate counties altogether at any time it wants to. So a county is nothing more than part and parcel of the state sovereignty. And once we understand that, we understand that county law is state law. It is clear that any state, Kentucky for instance, could have passed a right-to-work law. That's the unions concede that. But in doing so, they could have also passed a right-to-work law that applied in Louisville, in Lexington, in various places in the state. It didn't have to apply them to all areas of the state. So if they can enact a state law to that effect, our argument is they can delegate the authority to counties to do the same thing. And that's what they've done. In Kentucky, as I think Mr. Waters noted, we've enacted a Home Rule Act, as many states have, in the 1970s, and it's at KRS 67.080, and it allows counties to regulate commerce, to enact ordinances for economic development and other things. Well, it is clear, one can argue whether right to work is good or bad, but one can't argue that that's the point of right to work. The magistrates could be wrong. We think they're not, but they could be wrong. But they're doing it in an effort to regulate commerce and to provide economic development to the county. So it clearly falls within the home rule designations of, or delegation, I should say, from Kentucky. And I would note that the unions don't even challenge the right of counties to enact these ordinances under the Home Rule Act. They don't say that it violates the Home Rule Act. They only say that it violates the National Labor Relations Act. And I was talking about the first principles a second ago. The United States Supreme Court has said numerous times that the federal government can occupy the field and enact different policies, but in doing so, it can't alter the state government, the way the state runs its business. So my argument is, in 14B, I don't think Congress could have said political subdivision when it said state or territory. I don't think it could have said state, or could have said counties. Congress doesn't have the authority to empower counties. Only states can do that. And we've got a number of cases, in addition to the 10th Amendment, which says that, obviously everybody in here knows the 10th Amendment reserves anything to the states which has not been given to the federal government. But in New York versus United States, the U.S. Supreme Court said Congress can't require passage of state legislation. In the Prince case, it said Congress can't conscript local officials to do the federal government's bidding. In the Gregory case, the Congress said federal government couldn't, the U.S. Supreme Court said Congress can't enact qualifications for state officials. In the Highlands Farms case, it said Congress has no business altering the distributions of powers in the states. So it's a state question as to whether Kentucky wants to delegate the authority to enact local right to work or anything to its counties. That's Kentucky's business. If Congress doesn't like it, they can preempt the entire field, but they can't get involved in the way Kentucky enacts its own laws. This is not a novel proposition. I didn't make this up. State includes political subdivisions. It's been a time-honored principle, going back decades. In the United States Supreme Court has handled this issue twice since 1990. Once in the City of Columbus case, U.S. Supreme Court was interpreting the meaning of state law under the Interstate Commerce Act, the safety regulations in the Interstate Commerce Act, and in the Mortier case, the U.S. Supreme Court was interpreting what state law meant in the Federal Insecticide, Fungicide, and Rodenticide Act. Glad I don't practice that law. In the Mortier case. And what did the Supreme Court say? I'm not making this up. This is a quote from the U.S. Supreme Court's case, and it makes perfect sense. It's in line with our understanding of the Constitution. The U.S. Supreme Court says, the term state is not self-limiting, since political subdivisions are merely subordinate components of the whole, close quote. This is not controversial, I don't think. I know the unions don't like it because they don't like the outcome, but I don't think it's a controversial proposition. I think we win on the first proposition, which is that Congress never preempted the field. But even if Congress did preempt the field, if we grant them that, then they gave the power back to the states to enact right-to-work ordinances to disallow union security agreements. And the word state includes political subdivisions, if a state wants it to. Kentucky has. And this is common sense, right? There are lots of states, lots of federal statutes that say states are preempted. States can't do this. It is clear as can be that when Congress says states can't do something, they also mean political subdivisions can't do something, right? But in many statutes, when they actually do preempt the field, they use the word state law. That doesn't mean that Warren County can then do that which Kentucky can't. It's just common sense. Okay, so what do they say in response? There have been 4 cases that have dealt with this type of question. One is the Puckett case. What's that?
2 minutes.
One is the Puckett case from Kentucky. It's in the 1960s, but it had to do with a city, not a county. And cities and counties are very different. Cities are municipal corporations. Counties are part and parcel of the sovereignty and so forth. A city in 1967, which was before the Home Rule Act was passed, And then there's a case, City of Clovis, which agrees with them as well. But the court, the highest court to have considered the question is the 10th Circuit in 2002, and it's NLRB versus Pueblo of San Juan. And in that case, and I'll be quick, that case, the 10th Circuit said that the Indian reservation, to be fair, it was an Indian reservation and not a county, but the Indian reservation could enact a right-to-work ordinance. But what was the reasoning? In short, the court said, what Congress has not taken away, it need not give back. Never took it away, never preempted the field. I want to say real quickly, so that's the argument. I want to say real quickly something about this free rider hoax that we always hear. If it were true, it would be a darn persuasive argument. I mean, it's not fair that unions would have to represent employees and then they'd not have to pay anything, right? That's a persuasive argument. That's something that we understand. But they don't tell you the full truth. The full truth is when a union comes in to organize an employer, they have an option, two options. They can go the way they always go, which is to become the exclusive agent, which is to say they have to always represent the employees. And when in doing so, no other union can come in and compete against them. They always choose that one. But they could also choose, which they never do, they could also choose to be a membership-only agent, which means they only represent the employees who want to join. The problem with that is other unions can come in and compete. Now, in the Indiana Supreme Court case from November the 4th of 2014, the unions made the argument, free rider argument, not fair, not fair. And the Indiana Supreme Court said, we disagree. The union's federal obligation to represent all employees in a bargaining unit is optional. It occurs only when the union elects, not the employees, the union elects to be the exclusive agent for which it is justly compensated by the right to bargain exclusively with the employer. I'm reminded, I don't know if Lincoln said this or not, but we give all good things to Lincoln, so I'm going to say Lincoln. I'm reminded of the old Lincoln adage, which is this young man appearing before the court, having just been convicted of murdering his parents, pleading for mercy because he's an orphan. He's the reason that he's an orphan, yet he's saying, court have mercy. The unions are the reason that they have to represent all the employees, yet they say, not fair, not fair. It's their decision to do so. Thank you for having me. Look forward to any questions you have.
So we've now got some time for questions, and Samantha will be going around with the microphone. So if you've got a question, please raise your hand and then state your name and affiliation.
Connor Wolf, Daily Caller, News Foundation. My question's for Jason. Assuming the first argument is not true, and we go to the second argument, what states currently have some kind of law or provision that would allow counties to have their own right-to-work laws?
I haven't looked at all states. I know the majority of states have a similar right to work. I don't know how their courts have interpreted their Home Rule Act, but I know that most states have them, and it was a large move afoot in the 70s. Maybe James, who's been on the cutting edge of this, would know.
Yeah, there's several states that come immediately to mind. Ohio would be a very obvious example. They've got a pretty strong home rule statute. It applies to their cities, not so much counties, but at the city level in Ohio. Illinois, same thing. Basically, any city with a population of more than 25,000 has pretty strong home rule provisions in their state constitution. This is something that Ohio Governor Bruce Rauner has been championing quite hard. Illinois Governor Bruce Rauner has been championing. Maine has some pretty good home rule provisions. Missouri, on paper, has some home rule provisions, but the way their state Supreme Court has interpreted it doesn't actually give it as much.
I know Wisconsin does as well.
Yeah, Wisconsin does too. I know there was talk about doing this in Wisconsin before the legislature just did it statewide, and it became something of a non-issue. Now, interestingly, a state that on paper you'd think would allow this, California. There was actually a case that came back from the 1950s where the California Court of Appeals basically said, well, look, we're not going to rule on the federal policy issue because under state law you guys don't have the authority, which is a state's right. If a state wants to say that your counties can't do this, very clearly a state legislature can pass a law saying counties can't do this. But if they've passed a general a devolution of power through the home rules, and you haven't taken that back in any way, then Jason's argument, and I think it's a correct argument, is that counties are then free to do this.
And states, as Kentucky can recall it at any time. In Kentucky's Home Rule Act, there is a provision that says, essentially, if the General Assembly doesn't like it, they can pull it back. So states have that authority. Remember, the counties exist to serve the purposes of the state.
I'm excited too about what I've seen in other states. I spoke up in Ohio, and they had already done some research on charters. You know, the cities that have charters, and even the smaller towns that have that. The courts seem to have looked more favorably on that. But it's great to see the interest in that.
Thank you. Mr. Neems, my name is Steve Smith. I'm with an executive agency of the United States government, which shall remain nameless. I'd like to ask you why the union plaintiffs chose Hardin County as the test case instead of Warren County, which would seem logical as the first in line to trigger off this chain of events.
I want to note Mr. Smith's from Warren County, which is the first county to pass. I would also note that I'm a conservative, and as a conservative, I'm prudent. I'm about to argue this case in front of the judge, and so I don't know the answer to the question, and I'm not going to speculate. But they chose Hardin County for their reasons. I don't know why. They could have chosen Warren County. Maybe Jim wants to speculate, but
well, I wasn't going to speculate, but what I was going to say is that a lot of the counties in Kentucky, you know, we have 120 counties, and a lot of them are rural counties that really don't have a union presence. So we've encouraged those magistrates to go ahead and move forward because, you know, we don't think the unions will have a real strong case in some areas like they would in Hardin County where they have a lot of, you know, presence there, so, in companies. So.
Matt Patterson, Center for Worker Freedom. I wonder if any of you gentlemen could just talk about the mechanics of right to work now that Warren County and these other counties have that option. If a worker now wants to opt out of union dues, how exactly do they go about doing that? How can they take advantage of this new opportunity? And where can they go for that type of information?
Well, one thing I just want to say that needs to be said probably is that none of these ordinances that are being passed affect current contracts of workers. So, and this was a big issue, I think, with some rank and file members. They didn't want their current you know, they wanted some time to think about this and before they had to renew their contracts. So it doesn't affect that. It also doesn't affect any public employees. The teachers' unions are not involved. There's no public union in this. And so I think that's helped us also get to a bipartisan, really a strong bipartisan effort here. You know, more than 93% of the Republican magistrates have voted for this, more than 95% of the Democratic magistrates. So I think they see the value, and we've limited it. We've limited it so that, and that was part of our strategy, quite frankly, to limit that so that, so that we limited to the private sector and we really had impact there.
And going forward, had we made it applicable to the contracts that already existed, we would have violated the contracts clause of the Kentucky State Constitution and the United States Constitution. So we had to do that. I would note, to answer your question, so the hypothetical would be Warren County has a worker that works in a union employer, works for a union employer, and when the union and his employer renegotiate the contract, he will have rights to not join the union when the new contract comes into being. So it will be covered in the new contract. But effectively, it's just tell his employer he doesn't want to be in and so his money's not taken out of his check.
And you know, we're going to have that event coming up and thanks to ATR, and we're going to have an event there on next Monday night at the Corvette Museum right across the street from the Corvette plant. And the purpose being to, and I think it's very important, to inform workers how, you know, about this law and what their rights are. Because if you pass something and nobody takes advantage of it, then we haven't really made the impact we want to make. So I think there will be a lot of getting into the nuts and bolts of that at that. But you know, but that's essentially it. You're no longer required in those 12 counties to join a union or pay dues in order to keep your job.
States with that have already enacted a right-to-work law that also have a home rule law, would they be able to, their local towns or counties, would they be able to pass a law that that requires mandatory union dues in a right-to-work state?
The answer to that is you'd have to look at the individual state law. Normally, how home rule works is if the state law is silent, then the local ordinance, the local political subdivisions can enact an ordinance on the issue. But when the state law speaks to it, and in your example, the state law would have already been, we've got right to work across the state. The counties, in most places, I'd have to look at the individual state, but in most places, the counties cannot contradict that state law.
Well, the county home rule statute, I think in Kentucky, does indicate that that the counties cannot pass something that the state has specifically prohibited. And this has not been prohibited. Passing local county right-to-work laws has not been prohibited. So.
And that precise question is being litigated in the context of minimum wage.
Yeah.
Pretty exciting across Kentucky.
And that makes it tough for our Attorney General, by the way. As was noted by one of his Democratic colleagues, the county attorney in Warren County, and I think she made that point here at Heritage, that the Democratic Attorney General wants to be supportive of the city of Louisville's raising of their minimum wage, but he doesn't want to support right to work. So my theory is that he didn't even mention the county home rule statute in his ruling, because either way he goes, he's going to have a tough time with that as far as his political leanings go.
I don't know if you noted, but he's running for governor.
Yeah.
And my experience has been one doesn't run for governor without thinking of everything through the prism of running for governor. So.
I'm going to exercise the moderator's prerogative to ask a question. And one of the things I found very interesting from the amicus brief filed on behalf of the counties was the argument that none of the unions that are plaintiffs to the case have any valid claim to sue for damages, because none of them have a legally enforceable union security clause in their contract. That they all have clauses in the contract that require the workers to become full union members, which under existing Supreme Court precedent, you basically can't do. You can compel dues payment, but you can't actually compel them to be a member and associate with a private membership or association. That violates the free association rights implicit in the First Amendment. So just wondering, Jason, if you could discuss how at all, or how, if at all, you think that's going to play out, because it seems to throw a rather interesting wrinkle into things.
It does, and the county did not make that argument. It was the 11 counties, the 11 other counties that made that argument, and it goes to the standing of the 9 unions. In order to obviously bring a claim, you have to be affected, and what the 11 counties have argued is that the federal law says what you can and can't do in your union security clauses. These particular provisions don't comport with the law as the NLRA has understood it, and so therefore they should be thrown out, and therefore they don't have a right that's been affected. They don't have a dog in the fight because they don't have a union security clause that is impacted. Therefore, those unions don't have standing to bring the claim. Now, that is an issue that's very interesting insofar as it's a procedural issue. You have to have standing, you have to have actual harm, and so forth and so on. But it doesn't get to the heart of the case. And so we decided, at Hardin County, we decided to argue the heart of the case. I would also note that of the 9 unions, only 2 of them in their own complaint have even pled an injury, because there are 2 that are renegotiating a contract, the other 7 are not. And so we could have made a motion to dismiss those 7, which I think would have been successful. But the point is whether or not counties can enact these ordinances. But to your point, James, if the court does want to latch onto that, it's a way that it can get rid of this case and not decide the ultimate question.
On your point about the heart of the case, the 2...
sorry, could you introduce yourself?
Aloysius Hogan, Competitive Enterprise Institute. And about your point about the 2 hearts of the case, your first argument, which I guess was addressed in the Puckett case, the question there is, does that entail an overruling of Puckett, more or less, to win on that argument? And then on the second argument, National Right to Work is a player in the issue, and their organization, I posed the question to Mark Mix, their president, about, and he seemed to claim that somehow, and there was preceded with, there was a good event here at Heritage where one of their representatives spoke and alluded to a home rule statute. And Mark Mix seemed to claim that the home rule statute was somehow deficient and not as broad sweeping as he would like to see it for him to support the initiative, that under certain circumstances he could, in theory, support the initiative if there were broad enough, sweeping enough powers given in the home rule statute. I didn't know if you knew what it would take, or any of you, what it would take there to be sufficient for him to like it.
I just have a question on that. I mean, how much broader, with all due respect, I mean, how much broader do you get than counties can pass their own economic development ordinances? That's pretty clear to the counties anyhow, to the magistrates. So I would say that that's pretty clear, and that the state hasn't prevented it. So I'm not speaking to the legal question. I'm just saying I think the policy-wise that the magistrates have said, we have to do something to help our counties, and they see clearly the benefit of this. So
I appreciate that question. I think it's two questions. First of all, is your Puckett question. The case from the late 60s in the Kentucky Court of Appeals. The Court of Appeals said that the city of Shelbyville could not enact right-to-work ordinance. I said why that's different in this case, because that's a city and it was enacted prior to the Home Rule Act. But your question of whether or not the Court of Appeals got to the preemption question, the Court of Appeals did get to the preemption question and said that these ordinances are preempted. It wasn't brief, and I think the court got it wrong. But I would note that the Puckett opinion is a Kentucky State opinion, Court of Appeals opinion, and it does not bind the federal district court. The highest court to have addressed this question is the 10th Circuit. Now, the 10th Circuit doesn't bind the Western District of Kentucky either, because it's in a different circuit. We're the 6th Circuit. But the highest court to have addressed the question said that it wasn't preempted, and we think that's correct. Now, with respect to the national right to work opinions on the Kentucky Home Rule Act, I haven't heard them, so I don't want to speak to them in particular. I'd like to talk with him and see what he has to say about that. But I would note that as part of Warren County's effort, and Warren County was the first, as part of Warren County's effort to pass the right to work ordinance, their magistrates and the county judge, which is effectively the mayor of the county, for those of you who don't know what a county judge is, it's not a judicial position, it's kind of an executive and legislative position. He wanted to make sure they got it right. And so he got an opinion from his county attorney, who's a Democrat, got an opinion from the top law firm in Warren County, written by a Democrat, and then got an opinion from the former Chief Justice of Kentucky, Republican, and he joined with a former Justice of Kentucky, a Democrat, and he said, and Judge Buchanan said, do we have authority to do this? And what Chief Justice Lambert said is that it is, I think he said, beyond question that the Kentucky Act allows, the Kentucky Home Rule Act allows Warren County to enact the ordinance. Now, they were very clear to say we don't take a position as to whether or not you ought to, but the Kentucky Supreme Court Chief Justice and former Chief Justice and former Justice, opposite parties, served a total of 30 years or whatever combined, has said that it's without question. It's I forget the exact language, but he said it's clear as can be, and they were not taking a partisan position. So I don't know what his position is, but I would say that if you articulated it correctly, I think it's just wrong.
I think we talk about innovative approaches to policy, and sometimes then when we see those attempted, because it looks different than what we thought it was going to look like, that sometimes people who've spent a long time working on an issue with a particular approach, it takes a little while to adjust to that and think about that. So I've seen more political courage by our local leaders than I have in Frankfurt or anywhere else. I've really been proud of the way they've pushed forward on this. So.
We've got time for one more question.
Andrew Kloster with the Heritage Foundation. I just have a quick question. You kind of, and I walked in a little bit late, so maybe you did address this, but can you talk a little bit about local competition? You kind of alluded to the fact that you've got these occurring on the corridor along Tennessee. You've got them occurring along major thoroughfares. So I get that as kind of an initial matter, but I mean, like down the line, T+1, +2, +3, are you seeing sort of competition with kind of the way things are going in the nuances, and then et cetera?
Well, we mentioned here, I don't know if you heard, that Warren County, the first county to pass this, has had essentially more than twice as much interest in the county from companies in the first 90 days of right to work than they had in the decade before that. And we thought the decade before that wasn't that bad, you know, but this has been great. Another thing I would point out, even though a lot of the counties are along the Tennessee border, actually the most recent county to pass this was Boone County, which is in northern Kentucky. And that was a different environment because they are along the border of non-right-to-work Ohio. And Judge Gary Moore there, who's the executive judge, when they were debating this issue and right before they took the vote, he told the court that part of a consortium that they were part of, which is in greater Cincinnati area, if you know the geography, it's right there. And he said that he was told that if that county, Boone County, which is Kentucky's 4th largest county, passed right to work, that they would stand out, they would be much more competitive than the counties around them. So what we've seen, so it's not so much how many counties have done this as it is where they're located. And with Boone County doing this, there are already 2 neighboring counties who've taken the first steps toward doing this. And you know, these magistrates, they're talking, and these judges are talking to these to these companies and site selectors constantly. And so I think it's a great indicator, and what we're going to have and where we're headed here is competitive. You know, we've had competition among states versus with right-to-work laws versus non-right-to-work states. I think, depending on what happens with the legal case and what the state does, that if the state doesn't go ahead and pass a statewide right-to-work law, we'll see the same thing within the state. We'll see competitive situations, and I think we're already beginning at the very beginning stages of that.
I want to note real quickly, Boone County is right across the river from Ohio, which is non-right-to-work, obviously. And there are scores of counties in Kentucky that will pass and are ready to pass. They're just waiting to see what happens to the with the lawsuit. So, you know, there are 120 counties in Kentucky. We're going to have half of them that are right to work after this case is, if we prevail in this case.
All right, well, thank you, everyone.